Welcome, everyone, and thank you for coming to today's webinar on Copyright 101. It's going to be presented by Cheryl Davis, who's General Counsel of the Authors Guild. As you probably know, the Authors Guild counts among its several primary responsibilities, both the explanation and defense of copyright in the U.S. market. Cheryl's well-versed in the topic, but also a good friend of BISG, as is the Authors Guild. We're going to have about 20 or 25 minutes of prepared presentation from Cheryl, and then she'll take questions after that. I'll be monitoring the questions in both the Q&A box, and if you put something in chat, we may also look there. Feel free to do that as we go. But I'd like to start with no further ado with Cheryl Davis, General Counsel of the Authors Guild.
Thank you so much, Brian. For those of you who don't know much about the Authors Guild, we are the oldest and largest professional writers organization in the United States. We have over 12,000 members who write all sorts of books that run the gamut from journalism to novels to poetry to textbooks. And in my experience with the Authors Guild, I've had a good chance to deal with IAST, as Brian just mentioned, and to deal with any one of a number of authors on their various issues. And I'm here today with Copyright 101. And while copyright is a veritable ocean of material, I'm giving you the chance in today's about 20 minutes, or about a half an hour presentation, to dip your toes in the pond. Now, the goal of this presentation, if this will work, come on, there we go, is to give you an introduction to some of the basics of copyright law, which will include the affirmative and often judicially expanding defense of fair use. As a bit of free legal advice, fair use is an affirmative legal defense. It is not a verb. When I was in private practice, I had any one of a number of clients asking me, can't we just fair use it? And the answer to that is no. Over the years, the courts have interpreted fair use in an increasingly expansive way. And Congress and the Copyright Office have created an entirely new system for addressing small copyright small claims cases. So again, while you're just getting your toes wet here, they are going to get a little soggy by the end of this presentation. So let's start at the very beginning, a very good place to start. Copyright law stems from the Constitution. In Article 1, Section 8 of the Constitution, which authorizes Congress to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Now, what is the rationale here? The founding fathers, in their semi-infinite wisdom, wanted to encourage artists and inventors to create art and invent great things with the knowledge that they could financially benefit from their art or their inventions. And while some people dismiss art and artists with, they do it for free, the law recognizes a need to incentivize creators. And the term exclusive rights here allows creators to have a monopoly in their writings and discoveries, but this monopoly is limited, you'll note, because Congress did not want to stop progress by creating an unlimited monopoly, and the copyright law does have limitations. And here we have some brief explanation and a little more detail on this. Back when they were rewriting the copyright law in 1976, about the historical background, thus the primary purpose of copyright legislation is to foster the creation and dissemination of intellectual works for the public welfare, quite true. An important secondary purpose is to give creators the reward due them for their contribution to society. And the Authors Guild, that is very much our emphasis, to make sure that authors receive what is due them for their work. And here we have a quote from Harper and Row Publishers. It should not be forgotten that the framers intended copyright itself to be the engine of free expression. By establishing a marketable right to the use of one expression, copyright supplies the economic incentive to create and disseminate ideas. So essentially, by creating copyright, it created the industry that many of us take part in, the publishing industry. Now, what is copyright? Here, the law specifies that the owner of copyright has exclusive rights to do and to authorize any of the following: to reproduce the copyrighted work in copies or phonorecords, to prepare derivative works based on the copyrighted works. People might use slang and say that that's creating a prequel or a sequel or a movie out of a book. Those kinds of things are derivative works. To distribute copies or phonorecords of the copyrighted work to the public by sale or other transfer of ownership, or by rental, lease, or lending. In the case of literary, musical, dramatic, and choreographic works, pantomimes, and motion pictures and other audiovisual works, to perform the copyrighted work publicly. Essentially 0.4 is the performance rate. 5, in the case of literary and other works, the right to display the copyrighted work publicly. And here you have fine arts mentioned in here as well, pictorial, graphic, and sculptural works. And in the case of sound recordings, to perform the copyrighted work publicly by means of a digital audio transmission. Now, who owns copyright? Well, copyright arises upon creation. So essentially, copyright in a work protected under this title vests initially in the author or authors of a work. However, copyright also has the principle of something called a work made for hire. And in the case of a work made for hire, the employer or other person for whom the work is prepared is considered the author for purposes of this title. And that is essentially saying that the employer is in the position of the author because the employee is deemed to be essentially the employee, the worker essentially like the hands, the person actually putting into tangible form work that is owned by the employer author. However, work for hire is a little bit more complex than that, in that while work made for hire includes work prepared by an employee within the scope of his or her employment, it also includes a work specially ordered or commissioned for use as a contribution to a collective work, such as part of a motion picture or other audiovisual work, as a translation, as a supplementary work, as a compilation, as an instructional text, as a test, as answer material for a test, or as an atlas, if the parties expressly agree in a written instrument signed by them that the work shall be considered a work made for hire. Now, briefly, what this means is that not only can your employees be deemed to be your hands as an employer for purposes of work made for hire, independent contractors can create work that can be also deemed work made for hire, provided that work that they provide for you fits within these categories, and it has to be in a written instrument. So you have to make sure that your independent contractors are transferring their rights to you if you want to be able to license and deal with it as part of your collective copyright. Now, what is the term of copyright? Okay. Where you have an author who is an identified individual, where you have somebody whose name is on the copyright records, copyright protection will last for the life of the artist plus 70 years. Now, where you have a work made for hire, because often work made for hire will be owned by a corporation. You don't want to wait until a corporation dies, or where the author's name isn't disclosed in the copyright registration, say where it's an anonymous author or a pseudonym is used, and you can't know when the life of the author expires. Copyright protection in those situations lasts either 95 degrees from the first publication or 120 years from the date of the year of the creation of the work, whichever expires first. Oh. Okay. And I'm trying to move there we go. Now, copyright is often referred to as a bundle of rights. It means you can license a publisher to publish one edition of the work, but not a sequel. You can license plans or product designs to a manufacturer to reproduce and sell in one country. You can license rights for a flat fee on a royalty basis. The disposition of rights and terms is up to the copyright owner. And bear in mind, since copyright consists of those several different rights that we went through before, those 6 different rights, the right to copy, authorized copying, etc. Any right can be transferred or licensed without the others. So when you're deciding to whom to transfer rights, you want to keep in mind who can best exploit them for the profit, or better yet, for mutual profit. Agreements should be drafted and reviewed to make sure that only the desired rights are transferred or licensed on desired terms. In full disclosure, as the Authors Guild, we try to encourage authors to only license as little as they can to be able to maintain as many rights as they can. So essentially we encourage authors definitely don't transfer their copyrights, and only license the publisher to what they think the publisher can exploit adequately. Many cases, the publisher is the best person to be able to exploit the rights, no question. However, there may be situations where an author, say, has a contact in another country in which the book can be sold. And in that case, they may not want to license a publisher to be able to produce the book in that country because they have their own contacts. So likewise, like an author may have a relationship with a movie studio or a prominent screenwriter or director, in which case they might not want to authorize the publisher or anyone else to enter into movie deals. They may want to retain those rights for themselves. Now, what does copyright protect? It does not protect ideas, and it protects the expression of ideas. And that is very important because a lot of people think that copyright protects everything, but it only protects the expression of a particular idea put in tangible form. It does not protect facts. It does not protect processes, symbols, systems, principles, or methods of operation, or common tropes, plot lines, or mere formats, although it may protect the way these things are expressed. Again, the idea is that ideas are out there in the universe, and ideas can be used by anyone. It is the specific expression of those ideas that is protected under the copyright law. Now, while copyright arises upon creation, registration is needed to bring an action and to collect statutory damages and attorney's fees under the law. And what happens if you do not register if you do not register within a certain period of time before you bring your an infringement lawsuit, you may not be able to get what we call statutory damages, which is a significantly higher level of damages and requires less proof because you're putting it in the discretion of the finder of fact to determine how much damages you can get. And I'm gonna have another slide about that in a second. It says that a claimant may also be eligible to receive statutory damages and fees if the copyright is registered within 90 days of publication. So you've got a 90-day window after publication to still be able to register the copyright and get all appropriate statutory damages and fees. This is why the Authors Guild recommends that agreements require publishers to register copyright in the author's name within 3 months of initial publication. If you've seen our model trade book agreement, we have this language in there. Now you know why. Now, in terms of damages, if you have a copyright infringement action, if your specific expression of an idea has been infringed, in general, an infringer of copyright is liable for either actual damages or statutory damages. Actual damages requires the copyright owner, to calculate the actual damages that are suffered by them as a result of the infringement. So essentially, what has the author or publisher, whoever is bringing the copyright action, actually lost by result of this infringement? And they can present also proof of the profits that the infringer has gained thereby. Now, if you've got statutory damages, and sorry for the tiny print, it's a lot of language here, but in the cases where the copyright owner proves that so you get statutory damages, if you've registered in time, you can get statutory damages of between $750 or more, or $30,000 per act of infringement. And if you can show that the infringement was committed willfully, you can get the award can be increased to the amount of not more than $150,000 again per act of infringement. So these infringements can really mount under statutory damages. So yes, you should definitely register your copyrights. Now here, although copyright is literally a federal action, what has happened recently is because so many authors and artists have not been able to raise the money to be able to bring their own copyright infringement actions, because it can be cost you easily up to 6 figures in attorney's fees to bring even a relatively simple copyright infringement action. Now we have the Copyright Claims Board, which was loosely called it's a copyright small claims court. And as it says here, it is available to resolve copyright disputes of a relatively low economic value as an efficient, less expensive alternative to federal court. And this just started this past year. And it seems to be chugging along well. We will see how things continue to go. But if you have any particular cases that are small, under small claims, they deem like claims no larger than $15,000 or a total of $30,000 if say you have 2 claims in an action. So if you have claims less than that, this might be a suitable forum in which to bring those kinds of claims. Now we have respect to termination and reversion of copyrights. So we said that a publication contract may and should provide that parties can terminate under certain circumstances. For example, our model trade contract provides that an agreement can be terminated, like say by the publisher if the author fails to deliver the work in a timely fashion, or if the publisher rejects the manuscript, or by the author for publisher's breach of its material obligations under this agreement. There's also a statutory right of termination. Under Section 203 of the Copyright Act, authors can terminate licenses and assignments of rights that are made after 1978 between 35 and 40 years from the date of the first publication, or between 40 and 45 years from the date the grant was executed, whichever was earlier. And the way this works is that you have to actually provide notice of such a termination. I don't know if you saw in the news, but there was a termination claim made against the most recent Top Gun. When I believe it's the estate of the author of the article that the original Top Gun was based on, and they'd entered into those license agreements back in the 80s, I presume. I'm aging myself, but back when the original Top Gun came out, they had obviously licensed all those rights. In their interim, time has expired, and the estate of the author decided, you know what, I want to terminate those licenses. And they served a notice, and I gather that the argument the studios made is that, well, but we had already really done all the substantial work on the Top Gun adaptation before we received the notice, before the right of termination had been triggered. So we'll see what happens with that. There's also something called reversion of rights, which is where if the publisher fails to print, fails to pay, or allows the book to become out of print, we say that authors should have their rights returned. For example, as our model contract provides, that if the work is out of print after the expiration of 2 years, it's out of print through ordinary retail channels, the author may request the publisher to reissue the work. And if it's out of print, or if it does not respond, then the author should have the right to have the rights reverted back to them. Okay, and we are chugging along. So I did mention that I would discuss the concept of fair use to you. We've just touched very briefly on if a copyright has been infringed, essentially if there is copying of a specific expression of an idea. Does that mean that anything that you absolutely cannot cite to anybody else's work, you cannot copy any copyrighted work? The answer to that is it depends, because as we noted in the beginning, copyright is a limited monopoly, and you are allowed to use other people's copyrighted works in certain circumstances. For example, here under the fair use law, it says the fair use of a copyrighted work for purposes such as criticism, content, news reporting, teaching, scholarship, or research is not an infringement of copyright. And in determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include: 1, the purpose and character of the use, including whether the use is of a commercial nature or for nonprofit educational purposes; 2, the nature of the copyrighted work; 3, the amount and substantiality of the portion of the work used in relation to the copyrighted work as a whole; and 4, the effect of the use upon the potential market for or value of the copyrighted work. So these are the 4 factors that one needs to look to determine if something is a fair use of a copyrighted work. So hence the phrase, can't we just fair use it, is just a more complicated concept than many people realize. And so going back to the Campbell v. Acuff-Rose case, set up what we call the doctrine of whether or not a work has been deemed transformative. And in this case, Acuff-Rose Music, or essentially Roy Orbison's, sued rap group 2 Live Crew and its record company, alleging that 2 Live Crew's song Pretty Woman infringed Acuff-Rose's copyrighting Roy Orbison's rock ballad Oh Pretty Woman. The district court granted summary judgment for 2 Live Crew, holding that its song was a parody that made fair use of the original song. In reversing, the Court of Appeals found that the commercial nature of the parody made unfair under the first factor, that taking the heart of the original and making the heart of a new work, 2 Live Crew had taken too much under the third factor, and that market harm had been established. So essentially it's going through these various factors that need to be shown. And it says here, I'm just trying to dip through a bit. So parody has an obvious claim to transformative value. Like less ostensibly humorous forms of criticism, it can provide social benefit by shedding light on an earlier work and the process creating a new one. So essentially what the courts have tended to do these days is look to, well, we understand that you're using somebody else's work in yours. Now, have you transformed the work in some way to do that? And a lot of courts, unfortunately, have just tended to fall down. And well, if we find that you've transformed the work, then case closed. However, that's simply should not be the case, because there are 3 other factors that should be involved. here and mentioning the Authors Guild v. Google case in which the court said this copyright dispute tests the found boundaries of fair use. And in which case, what happened there was the Authors Guild and others had objected to Google's copying of any of hundreds of thousands of works, and making it available through those little thumbnail searches. When you search for a term in Google, you can pull up like 2 to 3 pages of a book. And the court found we have no difficulty concluding that Google's making of a digital copy of plaintiff's books for the purpose of enabling a search of those books containing a term of interest involves a highly transformative purpose in the sense intended by Campbell. See, we will see the transformative term again. The purpose of the copy here is highly transformative. The public display of the text is limited. It is not a significant market substitute. That's the 4th factor. And Google's commercial nature and profit motivation do not justify denial of fair use. I'll go a little faster here. How much is too much? In the Dodger case, they had, that was when they Jersey Boys was on Broadway, and they had a 7-second clip from the Ed Sullivan Show on stage. And the court found that by using the clip for its biographical significance, Dodger has imbued it with new meaning, and it's entitled to prevail in its fair use defense. I'm just zooming through here. Okay, this is the most recent iteration of fair use, which is actually before the Supreme Court recently. And I haven't listened to all the oral arguments, but I have heard that apparently Justice Thomas took this as an opportunity to state that he was a fan of Prince in the 80s. That's so. Actually, let me find my notes. In Warhol. Okay. In the Warhol case, photographer Lynn Goldsmith took a series of portrait photographs of then up-and-coming recording artist Prince. Vanity Fair licensed one of those photos to provide to Andy Warhol as an artist reference to create an illustration for a Vanity Fair article about Prince. Years later, Goldsmith learned that Warhol had also used her photo to create additional lithographs known as the Prince series, and that the Andy Warhol Foundation was licensing the image to the same market as her photographs. So now this case has gone before the Supreme Court on the question of, is this a transformative use? And we actually, the Authors Guild and a number of other organizations, submitted an amicus curiae brief, a friend of the court brief to the court, advising the court on the importance of derivative work markets as incentives for authors to continue to create new works. And we go back to, again, the limited monopoly in the beginning and the incentive of copyright holders to continue to create new works. Oops. Here's a fair use index if you want it. Okay. So when you should ask for permission, if you're using somebody else's copyrighted work, which includes song quotes, quotes from letters, photos, etc., anything that is not written by the person who is authoring the work in question, you still need to get permission to use them, unless one, fair use applies. We've been through a whirlwind description of how fair use can be applied. If the original work being copied is subject to Creative Commons or a similar license, in which case you need to abide by the terms of that specific license, which may include giving appropriate attribution, or if the original work being copied appears on a website that allows such copying or secondary use. And if you're going to rely on this, you need to read those terms of use quite carefully, because again, when I was in private practice, I had people coming up to me with all due innocence in their faces saying, but I found it on the internet, so that means it's public domain and I can use it, right? And some best practices are, you should pay attention to exactly what rights have been granted or transferred. You should make sure the terms of the grants in the contract are clearly stated, and this will be of special importance when you're trying to exploit those rights. Namely, you can't license rights you don't have. You want to also establish what will happen if either party breaches the agreement and how that might impact future licensing. Okay, now I can breathe and answer some questions. I'm sorry if I spoke too quickly. I usually do this in about an hour.
Charlie done a great job in a half hour, and I think everybody really appreciates it. We have a few questions that, but I do want you to take a deep breath just for a second.
Okay.
So one question from Meredith is kind of starting with why does a publisher want copyright? You know, or the alternative is, what's the benefit to an author of not transferring copyright or some aspects of copyright to a publisher?
Well, an author wants to retain their copyright because they want to be able to have some leverage and be able to exploit it in whatever ways they can. Because a publisher may not, as I said, a publisher may not be the best entity to be able to exploit the copyright. So you want to be able to, say, license it out the work to movie studios, to if you have other countries. Then it's a form of leverage, and it's also a form of it is your form of ownership. But the idea is that you don't want to transfer any more rights than you need to.
Right. And at the same time, a publisher for certain works or for certain types of books may be in a better position to exploit, and then the author can make that decision.
Of course.
Yeah.
Mm-hmm.
A similar thing, you talked a little bit about the damages that come from active infringement. And is there a method that courts go through to determine what constitutes active infringement, or is that highly
Oh,
subjective?
willful infringement. Yes, they will look at things like, did the party who infringed have knowledge of the fact that this work was copyrighted? There's the concept of an innocent infringer, which case somebody may have a book, or not a book, but saying they may have received an essay or something like that, or they may not know legitimately that this work is copyright. They may be one of my innocent clients saying, but I found this. I didn't know there was no copyright notice. I didn't know it was copyrighted. That's kind of tough to argue, but there is the concept of an innocent infringer. And what the court will look to in terms of determining willful infringement is essentially, where did the party have reason to believe that there was copyright infringement here, and did they actively infringe? It's like if somebody knowingly takes a work and strips the copyright off of it, which is a separate violation of a separate statute, and says, no, it's mine, I wrote it, then it's very easy to determine that these are actual willful infringement. You look at the pirates on Amazon on a daily basis, Amazon and other places. Amazon does try to take them down as soon as they get them. But we've had people report to us about somebody will copy their book and post it and sell it and not have the rights to do so. And that's a willful act of copyright infringement.
Comparable question from Kurt. How long does the copyright process normally take? If you have a book like a novel, how long does it take to make sure that you secured the copyright before going out to sell it?
Well, the copyright, it will go back to the date of application. But it can take, I'm honestly not up to on how long it takes these days. And I know it takes a matter of months before you'll actually get a certificate back.
Right.
Yeah.
You talked about the important work that's been going on with the Copyright Claims Board. What does a copyright holder have to do to bring a claim before that body?
Oh, well, there are forms that one fills out, and one goes to the website. I can circulate I can get you the actual website link. I just have a shot of it.
Yeah.
But what you do, and you actually don't, one of the beauties of that is you don't need to have an attorney to file a case for yourself. You can just do it yourself. It's like a pro se, it's like a small claims court. You have to fill out a certain form. You have to pay a fee, much lower fee than in regular court. And then you also, one of the things is you have, unfortunately, it is an opt-out system. So you have to make sure that the other party has been served, and the other party may then choose not to take part in the small claims system, which is one of the disadvantages of the system. But we have, as we've seen so far, people are choosing to opt in and take advantage of it, because essentially, if you get nailed with statutory damages, you're going to also get nailed with attorney's fees. And a number of defendants would rather put a cap on their potential liabilities by taking part of this in this small claims process.
Great.
But so what I can do, Brian, is send a link, and you can circulate it to the folks to the website, and they can see what forms they need to fill out.
That's appreciated, and I think that it's just early days for that process. So we'll have we'll need a little bit more time to see how it plays out. I was wondering if you could talk a little bit more about the model contract. You referred to it briefly, but what it is and where folks might be able to find it, because that's important work that the Authors Guild has done.
Sure. Our model trade book contract is available on our website. We used to have it behind a member wall, but we've decided that it's more important that all authors know what their rights are and get some idea on how to protect them in a publishing agreement. It's important for publishers to know what our approach is and what our rationale is behind asking for certain provisions. that we feel will benefit authors and publishers also in the long run. So that's available on the authorsguild.org website. So I can probably send you like a direct link to the trade contract, but if you go to our website and just put in model book contract on search, we've actually got an improved website now. You should be able to pull it up for yourself. And one of the beauties is that it's not just a template agreement with sample language, but it also has commentary explaining to authors, because not every situation, not every paragraph was going to apply to every author. So people have the opportunity to look through and say, okay, this doesn't apply to me. This doesn't apply to me. Oh, this does apply to me. Let me look at this paragraph and see why it applies to me, what the sense is behind it. And people can review our commentary to explain what we think is the rationale behind this language, and also how the author benefits by it.
I think many authors find it to be an invaluable resource. So thank you for making it available, and also for talking a little bit about it. And a couple more questions, and then I'll let you go. One is, it really does seem that fair use is determined in legal proceedings, not in declaration. So I can't decide if something is fair use. It's only when I get sued, for example, that I have to either defend it and find out that I'm right or not. Is that fair?
That is fair. What I can suggest is that if you think you're going to use a fair use argument, to have your ducks in a row. There was a case, I don't remember the caption of it right now, but it involved Family Guy. And they used some language from a song from Pinocchio. And they used song lyrics which belong to Disney, and Disney gets very cranky about these things. And just there was brought a lawsuit saying that, hey, you've infringed upon our copyright. And what the court did look to was essentially like, what was the rationale behind using these song lyrics? And they went to discussions that the writers had in the writers' room. And the court said, well, it looks like you did have a legitimate basis to argue fair use here. So if you're going to try to rely on something like that, then try to back it up and try to have explanations of, this is why I chose this is why I used how much of it. It is easier to do that beforehand, and the court is more likely to find it credible, than if you come to the lawsuit time and say it's a fair use, and the court says why. I say, well, because it's a commentary. Yeah. It's better that you be able to explain why it's a commentary.
So I guess part of it is ask permission if you can, and if not, then you can at least look at the situation and prepare for it. There was a question in the Q&A just about the PowerPoint. You had to go through some of the material relatively quickly. Would you be willing to share your PowerPoint? I know it's a lot of your own. Great. That I was going to say, you put a lot of work into it, and I don't want to just presume. So we'll do that.
I saw some typos as I was doing it too, so I need to fix those.
Saw none of those. So, well, thank you for that. Appreciate it. So one last question, it's just because if we're going to invoke Clarence Thomas, I wanted to know if you were a fan of Prince in the 1980s.
I was.
I
was a big fan.
Yeah, you and I actually have his first album, so on vinyl.
God.
So.
Oh, vinyl.
Yeah, I remember vinyl.
Yes.
Yeah, I bought it, I think, in 1978. So I'll bring it by the next time we meet.
Wonderful.
All right. I'm just gonna as we wrap up, I'm putting a link in earlier in the discussion.
Should I stop share now?
You can if you choose.
Okay.
We put links into a rights FAQ that we've introduced in the last month or so. It's not all about copyright. It does include some aspects of copyright, but also more generally about rights management. We intended like this webinar with Cheryl as a resource for people who are curious about how to approach topics related to rights, either from the author or the publisher perspective. And do take a look. There's a link I've just added to the page on which all the 4 links sit. You can take a look at that and bring back any comments, questions, or suggestions that you might have about either other questions or other answers we could add. Cheryl, thank you very much for doing this. I know you're a very busy person, and you have to.
No problem. I enjoy it.
Shepherd the Authors Guild through a lot of legal questions, but we're glad to have had you, and I know we're better off for it. Thanks, everyone, and we'll see you again soon.